Why should you avoid probate, and does a will do that for you? Sometimes I get clients that come in that are simply looking for me to do a simple will. They just want their stuff to go to who they want it to go after they pass, and they don't want any extra frills. Now, I have to tell them at that time that if you do a will, you are signing up your beneficiaries for a probate process. Probate is the process of proving that the will that was drafted and executed is indeed the valid will and it is correct. So if you have a will, you can't skip that process in order to use and effectuate that will. Now, for some families, that's fine. They may live in a low population area where their surrogate's court isn't backed up. They may not have any assets that require a lot of maintenance and may not need immediate attention at the time of their passing. So for some people, a will truly is a really good, valid option for their estate planning. However, for others, the time it takes for us to get through the probate process can significantly impact their beneficiaries of their estate as well as the assets that they hold. Because in the meantime, after you've passed and before an executor can be appointed, there's no person that can actually handle your affairs. Powers of attorney die when their principal does, so a power of attorney can't step in and help. And a will only controls assets that are in an individual's names. So we're not talking about joint accounts, we're talking about your personal pieces. So if you have personal things to your own name, for example, a house in your own name with a mortgage in your own name, and you sign your beneficiaries up to go through probate, it could be anywhere from 2 to 4 weeks just to get the paperwork together, to anywhere from 4 to 6 to 8 to 10 weeks for us to actually get in front of the court to get that probate process started with the correct paperwork for the court to even say, yes, this is the right will. You may now administer the estate. Now, different states have different things. So in New York, the big reason we want to avoid probate isn't necessarily that the process of getting into the court is so difficult. The surrogate's court does the best they can to make it accessible for everyone. They actually will give you public forums. The clerks can't give you legal advice, but they try to be as helpful as they can. The actual issue in New York is that once the probate is opened, there is a 7-month creditor timeline, which means you cannot close or dispose of the assets for at least 7 months. So however long it took me to get in, it's going to take me a minimum of 7 months before I can close it out. Now, that interim time, I can still maintain the assets. I can try to do things like pay for the insurance, pay for the utilities and the taxes on the houses, try to pay the mortgages, but I can't distribute a lot of the money outward as an executor until we reach that 7-month time frame. Because if a creditor jumps in and says, hey, the person who passed, the person who wrote the will owes me money, then the executor has to pay that debt. So they can't take all your assets, sell the house, and give the kids the money within 3 weeks. They have to take your assets, sell the house, collect the money, and sit and hold for at least 7 months, at least. If there's more assets to be collected after 7 months, there is no time frame that we have to close by. We simply can't close it early. So that creditor time frame will stretch from the date of the letter's issuance all the way to the end. Now, that's not even putting in the whole part about getting the letters, getting into probate. That's if it's easy to get into probate, then we have that problem. But for many families, getting to the letters is actually the struggle. And that can be for a number of reasons, right? It can be that your siblings, or like the siblings don't get along, they don't necessarily agree with what's written in the will, or it could be as simple as one of them lives on the other side of the world and doesn't have access to a notary. So we have to go through a process of citations to make sure that they have indeed been duly heard by the court. All of those things can come into a factor of play. So if you come in and you say, hey, I want to do my estate plan and I really just need a simple will, a lot of the questions an attorney is going to ask you is going to be around those aspects that a simple will simply will not resolve. And it'll be, hey, did you understand that if you do a will, you are signing your children up, you're signing your beneficiaries up for a months long, on average, probate takes about 18 months, so a year and a half, for a process for them to complete before they can even get the benefit of your estate? Or is that something you were looking to avoid and you thought the will might avoid that part? Because the wills And the administration, if I don't have a will, the process for administration is actually very similar to the process of the will. So if that's what I'm looking to avoid, then a will won't do it. We need a different tool in our estate planning belt to get there. Doesn't necessarily have to be a trust, but we at least need some different tools in our belts. If that's not the part that you're upset about or the part that you're trying to avoid, and instead we're just trying to avoid the statutory scheme of the administration. I don't want everything to go to my children. I don't want everything to go to my spouse. I don't want everything to go the way the statutes are. Then a will could be a perfectly valid option. But understanding how and why you want the will and then the implications of that is really important, especially if you walk into an attorney's office and say, I'm looking for this particular product or this particular tool. Expect that the attorney is going to advise you. My name is Lauren Glenn. I'm an estate planning attorney in upstate New York, and I try my best to be able to match my clients with the plans that work for them. Whether it be a will, a trust, a transfer on death deed, or something in between, we do our best to help you. Do you have a will? If so, let me know. What was the process like for you to get it? Put a comment down below. It's always great for us to hear experiences so that we can tailor our experience for our clients better. Have a wonderful day.